A major political, philosophical, and legal shift took place because of the decision in Bray.
On this day, October 16, 1991, these people were lined outside the United States Supreme Court building waiting to get a seat to hear arguments on a case called Bray versus Alexandria Women's Health Clinic. At stake was whether federal courts should use their authority to stop pro-life advocates from blocking entrance to abortion facilities.
The pro-life movement, like every other social protest movement, must be protected by the First Amendment.
In our view, anyone attempting to block a clinic, for example, and prevent someone from going inside an abortion clinic is interfering with that person's exercise of that fundamental right.
The case that was just argued is a case in which the court will decide whether women are going to have any protection against illegal attacks by mobs and vigilantes.
What other group do you know of that has federal lawsuits being brought against them when they block facilities? None.
What these respondents were trying to do is stamp a badge of illegitimacy on a social protest movement. And the federal courts do not need to become monitors of state trespass actions, and that's all this is. It's a state trespass action. At best, it's a obstruction statute, and that's what's involved here. And these should have been in the state courts, and federal courts should not be put in the position of stifling civil disobedience.
Abortion advocates use the argument that pregnant women seeking abortions are a special class of people, and therefore should be protected under an 1871 law called the Ku Klux Klan Act.
Well, I think the key issue is that women are a protected class, or women seeking abortions are a protected class under this particular law.
As a woman and an attorney, I don't feel that what these people are doing by sitting in clinics is exploitative of women or discrimination against women.
No way could they apply this KKK law to the effort on the part of the pro-lifers to save lives.
The KKK statute was enacted to prohibit conspiracies to deprive former black slaves of their civil rights. The lower courts have interpreted the KKK Act to cover class-based hostility. The question is whether pregnant women seeking abortions are a legitimate class under that statute.
The fact that they're being targeted because they are pregnant makes them a protected class.
The law's gone haywire. It's so far outside of the scope of what the Ku Klux Klan Act was supposed to do. The trial judge himself said that this was basically a simple trespass action. Then why don't they treat it like one?
The statute was never intended to deal with what are essentially local issues involving trespass.
The idea that opposition to abortion was equated with discrimination against women, which was the argument that the National Organization for Women and Planned Parenthood made over the years. We exploded that myth in Bray, the Bray case. Clearly, Bray said opposition to abortion does not constitute discrimination against women.